כמו בקללה הסינית, אבל סטרואידים.
שלומי הצטרף אלינו, יובל.
Okay, so without further ado, good midday, good morning, good evening for those following us from different time zones. My name is Yuval Shanem from the International Law Forum, and I'm very pleased to open this what appears to be a very interesting meeting, which is taking place in the aftermath of very dramatic and tragic developments in the region. The last month or so has been a real roller coaster here, with a series of events unraveling in breathtaking speed, and with reverberating and, in fact, for many here, surprising effects, both in terms of the sort of a chain reaction that we have seen, how events in Jerusalem, which started as a local issue about evictions, has become a larger issue within the Jerusalem context, involving also the mosques. And then this has deteriorated fast to a significant military conflict in the south, between Israel and Hamas, and to violent and almost unprecedented outbursts of intercommunal riots and violence within cities inside Israel. So many here were taken aback both by the intensity of the events, their implications, and also, I should say, of the very dramatic or very strong reaction we have seen at the international level. And we wanted the International Law Forum, as a body that is engaged in research in international law issues, teaching in international law, to try to take some stock of these issues, focusing naturally on the international law aspects of the three sets of events that we have seen, including questions relating to their interrelatedness, and also to the extent that these events can be, and how these events could be or should be understood, in the sense that they are all taking place against a context, which is an historical context, political context, but also a legal context. So we will try to flesh out some of these issues in the next hour or so. And we have a very strong panel of speakers, all working in the region and having a lot of experience in international law and law in the region. I will introduce them very briefly, and then we will have some rounds of discussion. This is not a session in which participants have prepared lectures, but rather it is a conversation in which comments would be offered by speakers on whatever dimension they choose to express themselves on. Our five participants are Professor Eyal Benvenisti, who is a very well-known international lawyer, chair of the Lauterpacht Center at Cambridge, and also member of the faculty at Hebrew University. Advocate Shlomi Zharia, who's a leading attorney in the Israeli context, working on human rights issues for many years, also a graduate of Hebrew U. Pnina Shavit Baruch, who's a lawyer and a retired colonel in the military. Pnina teaches international law and also researches international law at the INSS, which is a major think tank in Israel dealing with strategic affairs. And Pnina headed when in the military, she headed the international law department for the IDF. I would imagine that she's speaking in personal capacity, and she will probably would also clarify this when she starts speaking. Professor Yael Ronen from Sharei Mishpat College, but also Hebrew University, and the academic editor of the Israel Law Review, and also a member of the International Law Forum. And Dr. Sami Arshid, congratulations for the PhD, which has just been attained recently. But Sami is not a new hand. I mean, he's a veteran lawyer who's been working extensively in the Jerusalem area and has been representing some of the families in the Sheikh Jarrah neighborhood. who are facing eviction. So the way we decided to construct this would to have three rounds of discussion. The first round would look at the issues that took place in Jerusalem from mid-April onwards. Mid-April, we started seeing a rise in the tension in Jerusalem around certain street incidents, which were then filmed in TikTok and put on social media. Then the temperature gotten higher with the cancellation of the election, the Palestinian Authority elections, and then demonstrations which have been taking place all time for a long time in Sheikh Jarrah suddenly gained significant traction around the date in which the court was supposed to deliver a judgment involving one of the eviction claims. Eventually, the court hearings were postponed for a month or so. And then riots started taking place in and around the Temple Mount, involving almost, I think, unprecedented police intervention in the events. And I think that this chain of events has been a significant catalyst for what then follows in Gaza and on the streets of cities within Israel proper. I would like now to turn to our speakers and perhaps have their observations on the developments that took place in Jerusalem, and of course the international law aspects which should be considered when thinking about the background of these developments, but also of how these developments actually unfolded and what are their implications. So maybe Ayala can ask you to start.
Yeah, thank you. So I want to briefly refer to the situation in Sheikh Jarrah and specifically refer to the argument made by the Israeli Ministry of Foreign Affairs that this is a private matter. It's a matter of private law between two private parties, and the state has nothing to do with it. One word of background, the property used to be property of Jewish owners, but in 1948, it was transferred, ownership was transferred to the Jordanian custodian of enemy property, and based on a Jordanian law that in turn was based on a British order, trading with the enemy. And the Jordanian custodian authorized the families in Sheikh Jarrah to build their homes in that land. Now, in 1970, the Israeli law that was applied transferred the property owned by the Jordanian custodian to the Israeli custodian. And the Israeli general custodian was authorized to manage and return property to original owners. Now, according to Israeli law, the general custodian is under a duty, a mandatory duty to release the property to its original owners. It has no discretion in terms of release. But as we know, in Israeli administrative and constitutional law, any act must be, any administrative act must be based on a proper examination of the situation and the legal claims. So the very fact that there is a requirement of a certificate of release signed by the custodian means that the custodian must execute the release only after locating the property and exploring all the matters pertinent to its legal status and the status of the claims. Now, here's my point. There was never such an inquiry. There was never an examination, an exploration of all the matters pertinent to the legal status and the claims to the property. And that automatic release was endorsed by the Israeli Supreme Court twice, in 1981 by Justice Landau, and in 2017 by an opinion of the Israeli Supreme Court written by Justice Daphne Barak Erez. And so I think that two steps that seemingly privatized the problem. One is the action or the omission of the Israeli custodian to release the property without any inquiry. And second, the Israeli courts' refusal to make the point that an inquiry must be made. Thank you.
Okay, Sami, do you want maybe to add on this? This is something you know very well. You're on mute, Sami. You have to unmute.
Okay. Thank you very much for gathering also this forum to discuss the recent developments and the issues in Sheikh Jarrah, Jerusalem, and in Israel as general, and the conflict with the armed conflict with Gaza, because I think that it is good to gather again, and it's maybe the right forum to discuss the deep issues, also the legal issues of Sheikh Jarrah. I want to thank also Professor Benveniste for putting the facts, the relevant facts of the case. The case of Sheikh Jarrah is one of the oldest cases in the Israeli courts. It started in 1972. The first round of the cases, and we are now in 2021, and there is no substantial conclusion, legal conclusion of the right issues involved in Sheikh Jarrah. And this happened because, as Professor Benveniste mentioned, the first legal cases which were brought to court in the 1970s after the release and the registration that was made by the custodian and the Jewish committees that they claimed the land. The first cases that were brought to court in 1972, 1974, and the decision of Judge Landau, who became to be the president of the Supreme Court later on, they discussed the influence of international law on the position and on the status of the residents, the Palestinian residents of Sheikh Jarrah. This is the reason why we find in the first two rounds in the 1970s and also in 1981 by the most famous cases, decision that was made by the district court, 3 judges regarding the case of Sheikh Jarrah. The Israeli court rejected the eviction claim that was brought against the Palestinian residents. Although the court did not discuss the main issue and did not rule in the main issue, what exactly are the rights of the Palestinian residents who entered these houses according to an agreement with the UNRWA and the Jordanian government. But the President Landau made a very precedent in 1972 when he decided that all actions were made by the Jordanian government are legal and we have to respect them. Therefore, he came to a conclusion that the Palestinians are not trespassers, and he rejected the claim that was brought against them. Unfortunately, in the second round after 1987 and the third round of cases of Sheikh Jarrah, the courts in Israel stopped to discuss or even to argue or even to look or to hear to the arguments of international law, the principle of continuancy, and the responsibility of the State of Israel as the subsidiary of the Jordanian government. And therefore, they just minimize the case to be a simple property case between an owner and the possessor. This is the reason why we regret that we came to this date in 2021, and there is no substantial decision from the court in the heart of the issue. What is the right balance between the competing rights here in the case? The claim of the Jewish owners, original Jewish owners who claim that they owned the land before 1948, and the Palestinians who gained this position under illegal and lawful agreement with the Jordanian. This is the reason I believe, and I want to add also to the aspect that Professor Eyal Ben-Venishti put here. It's not just an issue of international law of human rights and the competition between only the right of possession or the right of housing versus the right of ownership. But also we believe that it involves the basic issues of international public law, also the status of Jerusalem. We have to bear in mind, I represent the Palestinians, and I hear from the Jordanian side, and also I brief a lot of diplomatic missions still. I mean, we have to bear in mind that there is a debate between scholars and international lawyers about the legal status of Jerusalem, and not all agree that the Israeli domestic law is lawfully implemented in East Jerusalem. On top of that, also we have to bear in mind, and this is one of the most fundamental issues in the case Jarrah, in the case of Sheikh Jarrah, and also I think the most influential issue to the Israeli public. All the 28 families in Sheikh Jarrah, they are Palestinian refugees who fled their homes in 1948 in Israel proper, and still they are under the Israeli absentees law that denies them the right of the return and even the right of claiming the original ownership of their property in Israel proper. I think these are the main legal issues that also need to be addressed by international law tools. And if they will be involved in the case and emerged, it will be made much easier to the court to reach the right decision.
Thank you, Sami. Now we're going to ask for the remaining speakers if they want to intervene briefly and maybe say something also on the more symbolic dimensions of the Sheikh Jarrah case, because there are many cases in other than Sheikh Jarrah that have similar settings. I think in Silwan is the next flashpoint for this category of cases. Yael, and then Shlomi, and then Pnina, briefly.
Yes, thank you. So I want to kind of pick up on what Eyal said earlier about this being presented as a private matter, and to add something that it might not be directly legally related, but is very politically related, and that is the fact that alongside the legislation that he mentioned, there's legislation about the property of Palestinians who have left Israel in 1948, and whose property is in Israeli hands. And if those Palestinians are within Israel or under Israeli control, they cannot receive their property back. So while these are completely separate pieces of legislation, politically, and this is how it's regarded, at least internationally, and I think it's now more than internationally, these are regarded as related issues. So what we have here is a political issue that is regulated under domestic law and is presented as merely a private law matter. And what we see now is that this doesn't work. I mean, you can't sell it. At present, the situation with the specific case of Sheikh Jarrah is that I don't know whether to say even the Attorney General, but the Attorney General has asked to intervene with the acknowledgement that this cannot be left entirely to private law. Now, this goes beyond Sheikh Jarrah, because there are other cases that have been discussed in court yesterday, and the court has decided to wait and see how the Sheikh Jarrah case develops, because the Attorney General's opinion, which brings in public law and perhaps international law considerations, brings it into the picture. Maybe that will be relevant there too. We have yet to see how the court will rule. But I want to connect it to Gaza, to the events in Gaza, in two respects. One is, and I know, Yuval, I have to be brief. I'm trying to do that without actually speaking faster, which is always a good solution. One is that this idea of turning a political issue into a private law matter is something that we've seen in the West Bank. I mean, the settlement regularization law was an attempt to solve a political issue through public law. It did not succeed. The Attorney General objected to it, among others. But what the court said was, maybe we don't even need this public law, because private law arrangements will, private law doctrines may be the solution in the sense of Israeli settlers may be able to take property of Palestinians, of Palestinians through private law doctrines. And I'm just wondering whether the fact that even in Jerusalem, thinking of it in terms of private law and private domestic law is not working, how that would affect the West Bank. Now, how does all this connect to Gaza? I think the fact that Hamas thinks that they have something to say about what's happening in Jerusalem, and the world does not think that these are completely separate, the international community does not think that these are completely separate issues, is perhaps a step in breaking the illusion that the Israeli authorities have been living under for a very long time. One is that if we decided that Israeli law applies in Jerusalem, and this is part of Israel, then Jerusalem and the West Bank and Gaza Strip are completely different entities, and there's no connection. Apparently there is still a connection. And the other thing is, and this is part of a broader picture, is that I'm speaking of Israel here. Israel always speaks in terms of the conflict as something that started in 1967. It's about occupation. And I think now we see that the argument that the legal conflict, even the legal conflict goes back not to 1967, but to 1948, is coming to the fore. How this is going to play out, I'll let the other speakers tell you.
I think you're generous about 48. I mean, there are those who go to 1917.
The legal conflict. I'm not talking about the political one.
Yeah, I mean, I think a good question that maybe the panelists could weigh in on later is why now? I mean, because these cases, these cases about evictions, they've been with us, like we've heard from Sami, from the 1970s. So why did they reach a boiling point at this point in time? Shlomi, to you.
Thank you, Yuval. Thank you all the rest for this amazing panel. I'll depart from what you just said, Yuval. Why it has started now? I think it's the Sheikh Jarrah demonstration, for example, are in East Jerusalem for, as far as I remember, 10 or 15 years, when this legal cases, whether in Silwan or Sheikh Jarrah, has emerged 15 years ago or so. But why now? I think it's all together, both the cancellation of the election in the Palestinian Authority, which derives partly, or as it presented as an excuse, that Israel is not allowing the Palestinians of East Jerusalem to take part in this vote. The reasons for that and who demanded the cancellation it doesn't matter, but this is another part. The issue of the Nablus Gate, the close down, and the entire issue of Temple Mount, when it came together with the Jerusalem Day and the end of the Ramadan, all itself created these tensions that, if you remember Spike Lee, a movie, Do the Right Thing, that in just 24 hours, what happened created, all the pressures in the last 70 or 100 years or so. So that's how I think and these issues are coming. Back to the Sheikh Jarrah issue, and I refer to what both Yael and Sami said. I think this two aspects of first, the discrimination nature of the legal aspects in Israel when it's come to refugee status and custodian issues is formatting the legal atmosphere that allowing the privatization of the conflict. And the privatization of the conflict, saying that how Eyal, you mentioned it, that the Ministry of Foreign Affairs noticed that it's not our point of view, it's not ours to decide. I think this is turning a blind eye who created this legal environment, and obviously who created this legal environment is the Israeli parliament and the Israeli government. But as we view in all cases, both in Sheikh Jarrah as well in Silwan, the court asked the Attorney General to take part and to intervene, not in the conflict itself, but to state its position in these two cases. And it will be very interesting to see what will be the position of the Attorney General, both from human rights issue, whether international or constitutional issues, and whether from other what many times being described as policy or political aspects of this conflict. And I'm eager to read his positions in all cases, whether Silwan or Sheikh Jarrah. I read, Eyal, your article in Arts about possible solution about the sort of confiscation of this land, and that's also bring the state authorities to get intervene again in this conflict and not let this to be a private issues. And it raised a lot of questions. Obviously, the similarities that some will ask to the regularization bills, though the normative frameworks are completely different. But we must remember that in Jerusalem, and in East Jerusalem in particular, the number of lands that were confiscated from Palestinians and were derived for Jewish entities, Jewish settlers, Jewish even Jewish companies, like the headquarters of Amana. I don't know if you know the Amana, which is the biggest entity that builds in the West Bank, is built on a land that was confiscated from private Palestinian persons. So it can bring into such an equalizers. And yes, yeah, I think that what we see in Jerusalem today is so-called of Hebronization of East Jerusalem. Hebron was, or other aspects in the West Bank, was just a lab for what we are viewing here. And I think we'll discuss more about this in this third part of this session. Thank you.
Thank you. Pnina, do you want to add something?
Unfortunately, I'm saying this, I'm not an expert, and I didn't deal with the issues regarding Sheikh Jarrah. I'm saying this because I do feel that maybe the panel lacks a little bit of balance by maybe bringing someone who can represent better than me the Israeli position, not because I necessarily agree with the position of the Israeli government, but maybe just so it will be heard in such a discussion, because I feel that everybody on the panel are very critical of this policy. And again, I'm not here to defend it. I would point out two points. First of all, I think that in the Sheikh Jarrah issue, and in general, when we come to the whole law of absentee property, we have the law that is actually bases a lot of assets all over the country, yes, are based on this legislation, and including structures of universities. So it's something that from the Palestinian point of view and the Israeli, including the Israeli Arabs, it's an injustice, but this is part of the, I guess, the very basic struggle here in the country after the independence war. So we have to understand this is part of it. So yes, East Jerusalem is more complex, even because it was there were changes there after 1967. But we have to understand that this is part of the context of the basic conflict that we have here between Jews and Arabs on this very basic element of the establishment of the state. I think what I would point out on the Sheikh Jarrah issue is that here there's an issue of the law. What is now being done is applying the law as it is, and that's why also the court has a difficult time to intervene, because that's the law. I think during the years, what we saw is that the legal advisors and the courts were actually, I would say, defending the Israeli governments from themselves, which is a role that the legal advisors tended to do during the years when actually through all kinds of measures of reasonableness, for example, blocked all kinds of steps that maybe are okay by the law, but have problems maybe on other levels, including the possible deterioration of the situation and creating friction. And what we see in the recent years is an erosion of the status of legal advisors and of the courts. The attacks that we see on, they make it much more difficult for them to play this role. So I wouldn't expect that the legal advisor or the attorney general will be able now to block, while maybe some of the people in the government would like that to be the case, because then they would, on the one hand, do something that is more, that is the right thing to do policy-wise. For example, if you look at the legitimacy of Israel, and on the other hand, they could always blame the lawyers. And that's what was done many years, and now things have changed. So we don't have this break, someone putting brakes on the government, and that's unfortunate, because I think we shouldn't have got to where we did in this situation. And an idea of confiscation maybe is the right and logical thing to do, but again, politically, I don't see it happening. And just another point, and I'll end by that. I do think that we have to differentiate between what's happening in Jerusalem and East Jerusalem and all the sensitivities, and between the Hamas operation. I think for the Hamas, this was a pretext. The main reason that the Hamas decided to act was the cancellation of the elections, and the cancellation of the elections were not canceled because Israel didn't agree for the elections to be held in East Jerusalem. Even Israel didn't give an official answer on that. It was completely internal politics. Abu Mazen understood that he's going to lose the elections, and that's why he canceled them. And of course, giving an excuse that Israel did not allow was going to prevent elections in East Jerusalem, but of course that could have been solved also in different ways. And the Hamas that were expecting or waiting for these elections because they were expected to gain a much stronger political position through these elections, decided that okay, it will strengthen its political position in a different way. The different way is to hinge onto the situation that is boiling in Jerusalem and become the protector of Jerusalem, the protector of Palestinians everywhere, including in the occupied state of Israel, as it is termed. They don't say state of Israel; they occupy the homeland. So I think this is what the Hamas strategic goal was. I would hesitate to accept this, not only, of course, for strategic point of Israel, it's a very bad connection to make. I think that the last thing that Israel wants is that Hamas will gain this position, but I think it's also bad for the Palestinians. And I think most of the Palestinians, both in Israel and in East Jerusalem, in the West Bank, I don't know if most, but many, are not very happy about the Hamas becoming their representative. I don't think they share the same ideology. So I think that the connection was made by the Hamas by firing rockets at Jerusalem, but the basis was a different, much more internal politics on the Palestinian side.
Okay, thank you, Pnina. And since you brought up the Gaza, I'm going to switch now to the Gaza conflict. I'm going to switch, and I'm going to start with you and then go to Eyal and the others. So I think you make a compelling case about, this being a pretext, certainly not hard to justify under international law shooting rockets at civilians under any situation, certainly in these contexts. But flipping and looking at what the Israelis has done in response to the rockets, assuming that self-defense was or some sort of use of force was legitimate, where do you see like the main issues that the main legal issues that that professional forums should be discussing about the Israeli campaign during Guardians of the Wall? A lot of the media attention went to the issue of proportionality and target selection. Do you think there are other issues, and what do you think briefly about these questions?
Yeah, I agree that the main issue is not the jus ad bellum, which I don't know is even relevant. It's an ongoing conflict, and anyway, this case, clearly the Hamas started, let's say we talk in a non-legal jargon. So I think maybe the focus is more on the jus in bello, and specifically on the targeting issues. And I think here the main questions and dilemmas, I presume that also on the Israeli side, and probably the allegations that will come refer to mainly to proportionality, also maybe a bit to distinction. To start with distinction is the main issue is civilian objects that have been hit, apparently civilian objects, civilian buildings. There were several multi-story buildings that were destroyed. Most of the buildings were not completely destroyed, I must say, in this operation. You know, the pictures that are shown are, of course, of the cases where the whole multi-story building was destroyed, but these are a few cases. Most of the cases are not. That's not what happened. But anyway, you had those, and you had, in general, attacks on apparently civilian objects, homes, and schools, and other civilian infrastructure, including the famous case of the Al Jala building that housed the Al Jazeera and AP offices. But here I think under the distinction, and I mean to those that deal with international law, IHL, international humanitarian law, or laws of armed conflict, whatever we term it, so it is understood that a civilian object can lose its nature as a civilian object and become a military objective if it is, among other things, used by the enemy to make an effective contribution to military action, and the destruction offers a definite military advantage. That's the formulation. It can also be by the location or the purpose, but let's say the use is, I think, the most relevant, maybe also location. So I think here, according at least to the IDF reports, I'm not, yes, and I will emphasize, I am not in the IDF. I don't represent the IDF. I wasn't involved in any decision here in this. I also don't have any special knowledge beyond what was published. So, but according to the official statements of the IDF, all the objects that were targeted were used by the Hamas, and either they were headquarters there, or ammunition, or storage of ammunition was used to fire rockets. You have all the tunnel system that it's a military infrastructure. The Hamas even doesn't say that it isn't. And in such a case, distinction is fulfilled because, as I said, the civilian object loses it becomes a legitimate military objective. There is a certain legal question whether, if it's a house-story building, the whole building becomes a military objective, or only, let's say, the apartment that is used by the Hamas, or the parts of the building that are used to put military infrastructure. I think the more generally accepted position, again, according to the law, is that the whole object, unless it's an object that can be that is distinguishable, that can be separate and distinct, and then you can't treat the whole object as a one military objective. If it's like a building, the whole building becomes a lawful military object. I think that's I'd say the position of most experts. But then we come to proportionality, and here the interesting question legally again, and maybe I have to say here a word about legal and legitimate, and in general about today in Haaretz, whoever saw Haaretz, you see the pictures of I think 69 children killed. And when you face these pictures, when you face, in general, civilian casualties, especially children killed, the feeling is immediately, if that happened, somebody did something unlawful. I mean, it cannot be. It's difficult to conceive that killing civilian children can be a lawful act. But this instinct, while it is understandable, it does not necessarily reflect the law. This is maybe the case when you are in a situation of peace, law enforcement. Any civilian killed would usually be considered at least a mistake at best, or at worst an intentional crime has been committed by, let's say, a policeman, police officer. But in armed conflict situations, this is not the law. The law understands that in armed conflict situations, civilians might be killed and the act could still be lawful. And this is something that is difficult sometimes to explain. It is very difficult also. It sounds heartless, yes, to talk about proportionality sometimes, and that civilian casualties, even if you know that they're going to be killed, it's still lawful and even legitimate maybe. And it is a very difficult argument to make when you're talking to the feelings of people. But that's the law. And I think it is important for me to emphasize as somebody who comes from IHL, that I think this is the right thing to do, because otherwise, if every civilian casualty would be considered a crime, we would create unrealistic rules that would be disregarded by warring parties, and most civilians would be killed where there is really no legal basis and justification. So the law is there to make sure that it is the minimum and not exaggerated the use of force. So coming back now to the proportionality itself, I think, so first of all, that
we are running out.
Yeah, so just say that how do you balance? So first of all, it's according to what is anticipated and at the time of the decision. And in some cases, maybe especially with the underground tunnels, maybe some of the casualties were not expected, because you don't always know where the tunnel starts one place, where it will suddenly crash another place. And secondly, the building itself is not part of the proportionality analysis. I understand that the buildings that were destroyed there were no civilians there, and the adjacent buildings were not harmed almost at all. So that means so the proportionality analysis is less relevant. It's relevant for collateral damage. And thirdly, just the issue of precautions, even in general, beyond the issue of distinction of proportionality, you also must take precautions to minimize harm to civilians. So we did see here the issuing of warnings, even in cases where it compromised some of the military advantage, not all of it, otherwise it wouldn't be a military objective. And also the issue, and I don't have time, so just about accuracy of weapons. You are allowed also to take into account, it seems that Israel did use accurate weapons as much as possible, but there's no obligation to completely disregard your supplies, how much weapons you have. And in some cases, you are allowed not to use or to keep some weapons and make a weapon inventory management is allowed by the law. And I'll stop here. I'm sorry, taking so much time.
Thank you. Yes, I mean, we are cramming a lot of very difficult and sensitive issues into a very short time frame. Actually, each of these topics would have deserved a separate session. Eyal, to you, can you please share with us your thoughts about what are the main issues that we should be looking at regarding the military campaign in Gaza?
Thank you. So I'll be brief. I don't repeat what Mina just said. Just one point, which is that the default is that targets are civilian targets. And in case of doubt, the assumption is that the target is civilian. So if the army decides to attack a target that on its face is civilian, the army has to demonstrate that it was indeed a military target. And so I think the jury is still out. We need to have an explanation why high rises were targeted. And there's still time. And if there is evidence, then this evidence should be provided, assuming that there is no issues of intelligence that are involved. So everything needs to be done in order to make sure that the international public understand what how the targets were chosen. And if there are mistakes, there's state responsibility, and the damages should be made. Just one point, not related directly to the conflict, but to the situation of Gaza. I want to remind everybody that Gaza is still in a state of siege since 2007, and sea blockade, naval blockade since 2009. So for 14 years, Gaza is in fact a prison for its inhabitants, and a long-term siege raises certain obligation, enhances the obligations of Israel in this respect. So it's not enough to think about how many calories people ingest in Gaza. It's also about freedom of travel and exploring life opportunities. Thank you.
Thank you. I move to Yael, and Shlomi and Sami, if you wish, I will also turn to you. But Yael, I mean, can you react if you wish? And maybe you want to address the issue of at least the allegations that the high rises were targeted for their also for their symbolic value. So this is the Dachia doctrine that you want to imprint that you want to strengthen deterrence by changing the landscape, so to speak. That doesn't detract from the fact that there could be legitimate military target. I mean, that there are legitimate military targets in terms of what is in them. But the question is, can you weigh this sort of consideration over and beyond the ordinary analysis?
Okay, so let me mostly react rather than make these broad statements. Two little small issues that one is small, is Pnina said, let's not get, the ad bellum question is less interesting or less important. And I generally agree with that, but I think Hamas started is a little simplistic, in the sense that the area is under blockade that I think Israel justifies on the basis of the laws of Nyack. Perhaps I'm mistaken, but you can't argue on the one hand that this is lawful under the laws of armed conflict and then say that there's no armed conflict. But I agree that it's the question of, and who shot the first shot is relying only on that. It would undermine some of Israel's other arguments. But I do agree that we've been through this in 2014, the discussion of how exactly do we even frame this, but the issues are mostly in the use in bello. And in that context, I just wanted to say something about I actually went through the Twitter, the tweets of the IDF, and this is what the general public sees. And going back again, building on what Eyal said, that the onus is on the military to show that these are military rather than civilian objects, and therefore they're legitimate targets. There's repeatedly, Israel bombed or shot or whatever, the operational apartment of various Hamas leaders. And in Hebrew, it was Dira Mivtzait. Now, I'm not exactly sure what an operational apartment is. If it's the place where a person lives, then I think it's just a civilian object. If it's headquarters, if there's an ammunition there, then that's the point. Now, operational apartment seems to me to be some sort of mix. On the other, the point is that this is where they lived and this is where they operated from. I'm not sure that this would fall under a military option because it's not by its nature, location, purpose, or use. So so they had a meeting there. Now will they not hold the same meeting elsewhere now that the apartment is bombed? So I find it difficult. It's also basically all based on trust us, we know it's military, and it's even the little that we're given is not very convincing. I'd rather not comment on the high rise. It's not there's nothing behind behind this. I'm not implying or insinuating anything. I'd just rather not comment on that.
Okay. Shlomi, do you want to come in on this as well?
Yes, well, I think that I want to refer to a few points that Nina just raised, and we cannot detach this conflict or this operation or this war, whatever you want to describe it, from the previous engagement in Gaza, whether it's Hard Cliff and Castlad in 2009 and later on, creating this entire doctrine of what is allowed and what is not allowed in Gaza, and what can be done, what cannot be done, is not something that fell from the sky in 2021. It's something that has its roots back in 2007, as far as I remember, and even before that. I will refer to two main issues that I find it a little bit contradictory. In one sense, I think that and I'm talking from legal point of view, not from the use ad bellum and the use post bellum or the use in bello, but the legal and the judicial responses to these actions. On the one hand, we have the ICC prosecutor decision and the ICC decision that's saying that the prosecutor has its jurisdiction for any events that occurred in Gaza. And we can add to that the ICC prosecutor statement that she might examine what happened in Gaza during this conflict. And obviously, I would have expected some aspect of deterrence, and maybe it has some aspect of deterrence in what was being done in Gaza. We won't know, but the results are, from my point of view and from proportionality point of view, are totally dissatisfactory. With all due respect, I think that in an operation that there are 280 dead people, that 67 or 69 are kids, and I'm not talking about the other civilians, their parents, the non-involved, that created even much higher. I can hardly describe this as proportionate, something that again to the issue of proportionate. And I still remember from the targeted killing case in 2005, how the IDF and the state attorney were very proud that, yes, we used the targeted killing operation in order not to take down these entire buildings. We have the entire methods and very sophisticated tools just to find in a specific apartment, in a specific room, what can be done. And if we'll go back, I don't know, to 1987, the IDF managed to catch and to assassinate Abu Jihad in Algeria, which is, I don't know, thousands of kilometers from Israel. So here, the only way to combat this sort of operational apartments is by bombing down the entire buildings. Obviously, it's I don't find it very reasonable. And
sentence, Shlomi, because we're really running out of time.
Okay, and the second issue is, and I started with the ICC, and the second issue is the Supreme Court ruling that was given in ACJ 3003 on 18 regarding the Gaza shootings in 2018. I think that this ruling almost backed all the positions and tools that are being conducted by the IDF, and I find it very, very dangerous. Not only the final decision of this, but the entire wordings that the court is, this court nowadays is refraining and really feel restrained from intervening in all these operational issues that are being conducted in Gaza. If we compare it to 2004 under the Barak jurisdiction and several intervening in the Rafah case and other aspects. So I find that this full backup from the Supreme Court is something that can be counterproductive, especially when we have the ICC on behind the shoulders. Thank you.
Thank you. Sami, do you want to weigh in on this?
Yes, thank you, Yuval. I want to try to address the question that you presented. Why now? In regard of the first topic we talked about, but just to talk about, to address it in the, also in the issue of the last armed conflict between Hamas and Israel that occurred as part of all the developments, the bad developments of the last year in the Israeli-Palestinian conflict. And when I think about why now, I do agree with Pnina that every political leader has his own considerations, and there is no guarantee that the public will ever know what exactly were the considerations of the political leader when he decided to go into war or to do any armed action. Unfortunately, the consequences of any armed action are so bad and so catastrophic for all parties, and we see that what happened in the last 8 days of clashes between Israel and Hamas in Gaza in the last day. And why now? Why now is very important. I think also it's related to the issues of international law in the Israeli-Palestinian conflict, and also in the context of Gaza, East Jerusalem, and the West Bank. We all know that Abu Mazen decided to cancel the elections that were supposed to take place, and they were supposed to take place in Gaza and in Gaza Strip, in the West Bank, and also in East Jerusalem. He justified that because the PA said that they didn't receive an approval from Israel to conduct the elections in East Jerusalem. This severely influenced the Jerusalemite scene that I hope I will address in 2 sentences later, but no doubt it addressed also, it influenced the situation in Gaza that is, as Professor Benveniste mentioned, since 2007, it's under siege in the sea and on the air, and we are talking about 2 million Palestinians there. So I think one of the fundamental questions that we have to reconsider again, reading all the articles published about the legal status of Gaza Strip after the redeployment of Israel or of the re-engagement of Israel in the Gaza Strip, whatever you like to call it, and talk about the people of Gaza. They were protected tenants under international law, under the laws of occupation. And suddenly, if we say that it is not occupied anymore, does that mean that necessarily and automatically they are entitled to exercise their right of self-determination? Because this is the point of view of Palestinians. So if I am entitled in the same under the same international law, I'm not under occupation, so I am entitled to exercise my right of self-determination. Is this exercise of the right of self-determination is divided? I mean, every part of the Israeli-Palestinian individually or partially is going to exercise it. Does the international law recognize that only the residents of Gaza are entitled to exercise this right, or they are entitled to exercise it as part of the Palestinian people? I mean, if the answer is they are as part of the Palestinian people, and this is what we hear from Hamas, they say, okay, we want to establish the Palestinian state, and we are entitled to protect our future capital, which is East Jerusalem. So this is how they brought the link to East Jerusalem, and also try to engage the residents of the West Bank into this issue. And I think this also needs a reconsideration from the aspect of international public law, not just from the aspect of conflict armed laws.
Okay, thank you, Sami. We are running really low in terms of time. We're going to have one final round with 4 of the speakers, because Professor Benveniste had to leave, and I think Pnina is also has to leave. So The final issue we wanted to briefly touch upon is the violence within Israel, between the inter-communal violence in Israel, and the question, is there an international law dimension, other of course than the general human rights concerns about protecting lives, property, physical integrity, preventing discrimination, etc. Does any of the three remaining speakers wish to weigh on this? Shlomi, do you want to say something?
Well, yes. Well, I think that I will not go into all these issues that you raised, but try to look at a little bit zoom out, especially when this crisis that we're facing is happening after 1 year of Corona crisis, and this how the state, and not only the state but others, become a little bit addictive to these emergency cases and declaring emergency cases. And this is one aspect of it. I mean, if you compare these riots that we were facing and the violence and all these other brutal accidents that were, I think that they are much less deadly than those of October 2000, for example, much less tense. And I say, from my personal point of view, as a person who lived in Jerusalem back then, it was in the heart of these issues. And but it was very, very easy to raise the use of emergency situation and emergency cases. And for example, the curfew of the city of flood that was issued by the Ministry of Defense. The idea to use the IDF soldiers and the IDF troops in order to settle the violence between the two parties. I'm really glad that it didn't come into something that became very active, but obviously it derives directly from what we are facing about the weakening all the other echelons and all the other governmental forces during the last years. And again, like in the Corona, using the army as the best organization to solve any problem. And another issue that came to my knowledge today, the use of administrative detentions against the Israelis and the people of East Jerusalem that started during the last week. All in all, I think that the atmosphere of using this emergency situation as justification to derogate from human rights or from human rights obligations or for other constitutional rights of the Israeli society, something that we must remember and check it. Even if we look about the Supreme Court rulings in the last year, when I counted the assistance of the Association of Civil Rights in Israel, around 6 cases where the Supreme Court intervened in the government decisions, but it was only in the margins, in my point of view, and it didn't get into the topics of these issues. And the core issues of human rights violations, it was dealing with the issues of who has the authority to do that, and whether it can be retroactively cancelled, etc., etc. But when it comes to issues of security and how you frame things in the issue of emergency situation, the court is really backing the state and the government and the parliament time after time. And I think this point was a little bit too risky in several ways, and the involvement of the IDF, and is something that this is not a situation that should be done. And again, I think this was way too much here.
Okay, thank you, Shlomi. Yael? Pass? Sami?
Shlomi summarized it well.
Okay, thank you, Yael and Shlomi. And I think we have to separate between two scenes internally of what happened in the last month. The Jerusalem scene is different than the scene of the Israeli Palestinian Arabs living in the mixed towns or in the towns and villages inside Israel. The Jerusalem scene had its own reasons and aspects of international law, and definitely the most fundamental issue here in East Jerusalem, that even after 53 years, we did not reach a point that the domestic legal means and domestic legal issues and even the domestic law is accepted by the Palestinian residents of East Jerusalem. They still see themselves as protected tenants and protected community under international law, and the issue of East Jerusalem is still in the heart of the conflict and has to be addressed also in international legal tools and international diplomatic tools. The scene inside Israel, this time it was different even than in the year 2000. I remember what happened and the clashes. They were much more violent in 2000, and we had 13 casualties amongst Israeli Arabs that they lost their life in the clashes of 2000. But if you heard the talks and what people talked about this time, it was different, and especially from the legal aspects and the conversation that involved for the first time, I believe, in the history of Israel, we heard calls of Arab leaders, some of them politicians, even Sami Abu Shhadi, who is a member of the Knesset, that he called for international protection for the Arabs inside Israel. And we heard this from many mainstream, even I would call civil associations in Israel, upcalling for the involvement of international protection. And in the first step, at least, the protection of international law as a tool for the Arabs of Israel. And the reason for this, and it's different from the year 2000, I believe, because especially in the last decade, we have two phenomena in the Arab society inside Israel. I mean, on top of that, we have the last very tough year of the COVID-19 period that we all suffered, and especially the Arab society. But we have two things: the violence that the Arab society is suffering from and increasing from year to year, and there is bankruptcy of the Israeli institutions in dealing with this phenomena. Every year we have more victims killed in the Arab society, and there is no response and no remedy even from the Israeli institutions. The other thing also, as we know as lawyers, is the decrease in the constitutional rights of the Israeli Arab citizens, especially on all the legislation actions that were made. Of course, the highlight of this legislation is the basic law of national state of Israel as the state of the Jewish people. That decreased, and the Arab citizens of Israel felt that it alienates them from the state of Israel. So the combination of the decrease in the constitutional status of Arabs in Israel, adding to this also the decrease of the participation of Arabs, or I would say the protection that Arab citizens receive from the institutions of the state of Israel, had for the first time brought to the scene and to the mainstream scene and discussion amongst the Arabs that maybe the Israeli human rights laws are not enough in order to protect us as equal citizens in the state of Israel, and maybe there is a need to intervene and maybe import international human rights law to the scene and to the discussion. These are the two things that I think are most that were very clear this time in the last 2 months, and what's happening with the Arab society in Israel in the aspect of international law and the human rights law in general.
Okay, thank you, Sami. Unfortunately, our time is up, so we are not able to open it up for questions. Maybe I can say briefly two final words before closing and thanking the organizers. First, I mean, I do not disagree with everything Sami said about the long-standing problems and crisis which the Arab community in Israel is facing, the Palestinian Israelis. I think it is, however, a more a somewhat more complex situation, because we were in a moment in time before the violence started in which Arab parties were supposed to be part of the ruling coalition in Israel for the first time since the state was established. So we were on the cusp. I mean, the Israeli media was talking about the honeymoon between Jews and Arabs in Israel. And suddenly this thing has happened, which goes to basically maybe suggest that we're moving one step forward and then 2 steps backwards. And this is maybe the story of our lives in this complicated region. The second thing I wanted to say is that I think for Israelis, these recent weeks has been somewhat of a wake-up call, in the sense that issues that we think that we're under control and that we shouldn't, you know, the Palestinian issue is no longer very interesting, and now we have peace agreements with the Gulf states, and we have the situation boxed. The Hamas is boxed in Gaza, and the PA is boxed here, and everything is under control. I think this illusion is somewhat blown up literally in the faces of many people in the region. And I would suggest that Israel's approach towards international law and the fact that these standards are not important and maybe have little bearings on reality may suffer from the same predicament. And maybe it's going to be also a wake-up call for taking more seriously the international law framework. I'm not saying this only because I'm an international lawyer. I also think that's you see here how the different pieces of the puzzle or the different domino pieces are linked to one another, and I would suggest that international law is at the background of all of these different developments. I want to thank all speakers for very interesting engagement and presentation. Also thank the audience. I want to thank Tal and Imran for putting this together, like always. Thank you all, and hopefully our next update will be on more tranquil topics. Bye-bye.
Thank you. Bye.
Thank you.
Bye-bye.